Legally Influential, a creator's guide to navigating social media law. Are you now or want to be a social media influencer? If so, this is the video for you. If you want to be a social media influencer, the grid is your business card. A single post can launch a brand, go viral, or genuinely connect with an audience. But sometimes I'm sure you're so focused on getting the perfect shot or the right caption that you don't think about the not so fun side. So today I'm taking off the filter and talking about the legal stuff you could seriously be impacted by for your business, from disclosure laws to copyright claims. If you want a long and successful career online, this is the video you need to watch. My name is Leon Jones Jr., and for over 15 years, I've practiced in both state and federal courts here in Arkansas. I've also worked for a Fortune 100 company, and I've held the positions of Director of the Arkansas Department of Labor and the Executive Director of the Arkansas Fair Housing Commission. Now, I'm the Managing Attorney here at Big Rock Legacy Law Group, where we advise and represent our clients in business law, civil litigation, estate planning, and family law. I hope this video provides some insight into how I provide my advice, which is different for every client. So part one, wait, I can be sued for this? First things first, why should you ever care? It's easy to feel like the internet is the Wild West. But here's the reality. Your social media accounts are a business, even if it doesn't always feel like it. And the same laws that apply to big companies like Coca-Cola and Nike also apply to you. Think of it like this. The more eyes on your content, the bigger the potential target. You've seen influencers sued for things they thought were harmless. It's not just about losing money, though that's bad too. It's about your reputation, your platform, and your long-term credibility. Today, I'm arming you with knowledge. Part two, disclosure, disclosure, disclosure. Meeting the FTC guidelines. If you're making any kind of money or getting any kind of perks, the Federal Trade Commission or the FTC's goal is simple: to make sure advertising is honest. If you have a connection with the brand you're promoting, your audience needs to know that. Now, I know what you're thinking. Is a mention in my stories really an ad? The FTC's answer is probably yes. So, what are the FTC guidelines and how can you comply? Well, there are three key FTC principles at play here, and here they are: clear and conspicuous, hard to miss, and no ambiguous hashtags. Clear and conspicuous. Your disclosure needs to be straightforward. Is a tiny ad buried in 30 other hashtags at the bottom clear and conspicuous? Probably not. It should be prominent and unavoidable, and use language that matters. Terms like hashtag ad, hashtag sponsored, hashtag paid ads. These, with your brand name, send the message that the product for a test. It's all good. Make sure you avoid vague terms like hashtag collab or hashtag partner, which don't clearly imply payment. Also, timing is key. Disclosure must come before you deliver the core message. In a video, say it verbally and use it visually. In an Instagram post, include it in the first few lines of the caption. It looks something like this. Here's some good and bad examples. A bad example: obsessed with this new cream. Click the link in my bio, hashtag skincare, hashtag beauty, hashtag glamour. These are too vague and are hidden hashtags. A good example is paid partnership with XYZ Cosmetics. I'm obsessed with this new cream. Click the link in my bio. Also mentioning in the video, XYZ company sent this to me to try. That's another good way to get your information out there. To learn more about how we assist our clients with these and other types of legal situations, click below and let's get started today. Number three, the money trap. Endorsement and review your rules. Let's talk about reviews and testimonials. If a brand pays you to review their product, you have a material connection to that brand and you must disclose it. But what if they just sent it to you for free with no strings attached? Even if it's a freebie, the FTC still considers it a material connection. So you still need to disclose that it was free. A simple gifted by XYZ brand works in this situation. But what happens if you genuinely hate the product. This is where it gets a little tricky. If you're under contract to review something positively, that's a different legal conversation. But if you're giving your honest opinion about a freebie, you can be critical. However, avoid saying anything definitively false about the product that could lead to a defamation lawsuit. What if you haven't tried the product yourself, but you're telling your audience how great it is? This is a major red flag. You cannot make false or misleading claims about your experience. If you haven't used it, don't say you love it. Part 4, your intellectual property. Don't steal and don't be stolen from. Let's talk about your intellectual property or your IP. This is a massive topic, but let's break it down into two main buckets for you creators: copyright, trademark. Number one, copyright. This protects your original works of authorship, like photos, videos, writings, or music. The second you create your content, you own the copyright to it. Here's the golden rule: do not use anyone else's content without permission. This means music in your reels, unless it's royalty free or from an authorized library, film clips in your YouTube intros, pictures from Pinterest, all of this. The risk here is that you could face copyright strikes, account suspensions, and massive fines for copyright infringement. Fair use is not fair pass. Many creators mistakenly think quoting a line or showing a clip is automatically fair use. Fair use is a legal defense with very specific, complex criteria. It's better and safer to just get the permission. Number 2, trademark. This protects things like identifying your brand, name, logo, slogans. While you generally won't trademark every piece of content, you should trademark your creator name and the logo as soon as you start monetizing it seriously. This prevents others from impersonating you or confusing your audience. Part 5, rights of publicity and defamation. Be mindful of others. Beyond the content itself, you need to be mindful of the people who may appear in or be affected by your content. The rights of publicity. So what is this? This is the legal right individuals have to control their own name, image, and likeness, or their voice if they're used for commercial purposes. So let's say, for example, you're out and you're taking pictures in a public park, and there's someone clearly identifiable in the background. If you post that on social media for personal use, then it's probably fine. But if you're using that image in a way that implies they endorse you or a product, using it in an ad, for example, that's a potential violation. It's always best to get a model release for anyone featured prominently in any commercial content. The next big deal is defamation, sometimes meaning libel or slander. Defamation is making a false statement of fact about someone that causes harm to their reputation. Drama channels often walk a tightrope when it comes to defamation. It is critically important to distinguish between stating an opinion and stating a fact. Saying, "I didn't think the food at that restaurant was good" is an opinion, which is generally safe. But saying the restaurant uses expired ingredients is a statement of fact, and if it's false, could lead to a defamation lawsuit. So be extremely careful when making negative claims about people or businesses. Part 6, the contract basics. Don't just sign on the dotted line. You've landed a brand deal, you're excited, but before you break out the confetti, there's a little thing called the contract. A lot of new creators make the mistake of assuming a contract is just a formality, or they're afraid that asking questions will make them seem difficult. Don't fall into this trap. A good contract protects both you and the brand you want to represent. So here's some key contract terms you need to watch out for: deliverables, usage rights, exclusivity, indemnification. So let's take each of those one at a time and let's try to understand what they mean for you. Deliverables: precisely what are you creating? The number of stories, the number of reels or posts, how long, the required tags. Be incredibly specific. Usage rights: how is the brand allowed to use your content? For one social media post, in their email campaigns, on billboards, and for how long? This directly impacts what you should be paid. If you want unlimited rights forever to give to them, that costs a lot more than a single story. Also, keep in mind exclusivity. Are you restricted from working from other competitors? For what categories and for how long? Make sure this is reasonable and spelled out in the contract. And don't forget the payment terms. How and when will you be paid? Net 30, net 60, upon approval? Is there an upfront component? Ask these questions and keep asking until you get the answers. Now, let's look at indemnification and how it can impact your bottom line. Now, this is legal speak for who pays if something goes wrong. Typically, you'll indemnify the brand for anything you do wrong, copyright violations, false claims, and they'll indemnify you for anything wrong with their product. So, my advice, don't be afraid to ask for edits or clarifications. And seriously, for any significant deal, have a lawyer review the contract. A few $100s you spend now could save you thousands or more and endless headaches later. Number 7, the ongoing legal health checklist. That was a lot, but navigating the legal landscape isn't a one-time thing. It's an ongoing part of your business. Here's a quick legal health checklist for your creator career. Number 1, read and understand the terms of service for every platform you use. Number 2, explicitly disclose every single material connection using ad hashtags, sponsored hashtags, etc. Be clear and conspicuous. Number 3, always use original content and get verified permissions and licenses for everything else. Number 4, clearly distinguish between opinion and fact, especially when reviewing products. Number 5, get model releases for anyone, any person appearing in your monetized content. And number 6, trademark your brand, your name, and your logo. And finally, number 7, have a lawyer review your business structure, LLC, corporation, your brand contracts. Navigating the legal world of social media might not be as glamorous as unboxing new products, but it is just as, or even more essential. Protecting yourself means protecting your passion, your business, and your future. I encourage each of you to evaluate your situation early, discuss your unique needs with qualified professionals to secure the best possible outcomes. If you found this video helpful, please hit the like button, subscribe to our channel, and learn more valuable information about how we here at Big Rock Legacy Law Group protect our clients' legacy and advocate for their rights.